Welcome to this comprehensive guide on reclaiming U.S. residency after long absences. In this video, we will break down the two main pathways, SB-1 returning resident and I-130 family petition, so you can choose a realistic and strategic path forward. To set the stage, we will outline our agenda and then provide a brief but important disclaimer before diving into the details. Here is the roadmap for today. We will start with who this topic affects, define essential terms, and then compare SB-1 and I-130 in depth. Afterward, we will walk through a decision framework, share document checklists, and reinforce learning with quick quizzes. Now, before we proceed, let's begin with a brief but necessary disclaimer. This content is for educational purposes only and does not create an attorney-client relationship. Immigration policies and procedures can change, and outcomes depend on specific facts. You should speak with a qualified immigration attorney before taking action. With that in mind, let's transition into who this affects and why the stakes are high. This topic primarily affects former lawful permanent residents who remained outside the United States for extended periods and now wish to re-establish status. It also directly involves U.S. citizen family members who are eligible to petition. With the context established, let's quickly align on core terms and the practical thresholds that shape decisions. Let's quickly define key terms. Lawful permanent residents are green card holders. Abandonment can be inferred by long absences or conduct inconsistent with residences. The SB-1 returning resident visa is for those who had continuous intent to return but were kept away by circumstances beyond their control, which must be proven with strong documentation. The I-130 family petition is filed by a U.S. citizen spouse or adult child, treating you as a new immigrant and bypassing quota limits if you are an immediate relative. A re-entry permit can help preserve status but does not solve multi-year absences once it expires. With terms in place, we can now visualize the decision process. This flowchart begins by asking whether a former permanent resident has been abroad for years. If the absence is under 2 years, and the person can present strong, contemporaneous evidence of intent to return and circumstances beyond their control, the SB-1 might be considered, though it remains risky. If the absence is 2 years or more, or if evidence is weak, the recommendation shifts to filing an I-130 via a U.S. citizen spouse or adult child. The diagram calls out that beyond approximately 4 years, SB-1 denials become common, and near 10 years they are highly likely. The two potential outcomes are re-entry through an SB-1 approval or via an immigrant visa from an approved I-130. Now that we see the logic, let's examine the SB-1 pathway more closely. The SB-1 route is controversial because applicants must prove an uninterrupted intent to return and that circumstances beyond their control prevented their timely return. After about 2 years, the government scrutiny is intense. After approximately 4 years, denials become likely, and near 10 years, denials are expected in most cases. Humanitarian reasons are insufficient without robust, contemporaneous documents. This process can be costly and emotionally taxing, with minimal chance of success after prolonged absences. With that sober assessment, let's outline the SB-1 steps for those who still wish to attempt it. If proceeding with SB-1, first verify consular procedures and eligibility. Then gather evidence of continuous ties to the United States, including tax returns, housing, financial accounts, and licenses. Next, compile documents proving the events that kept you abroad were beyond your control, complete with dates and records. Show that you attempted to return earlier through flight bookings or consular communications. Submit the required forms and fees, and bring your expired green card if you have it. Prepare a clear timeline and affidavits. Then attend the interview and answer consistently. Because refusal is common, especially after multiple years, ensure you have a fallback plan, such as transitioning to an I-130. Now, let's move to the more reliable path. The I-130 path treats the former permanent resident as a new immigrant. For immediate relatives of U.S. citizens, there is no annual visa quota backlog. Only processing times apply. This route typically involves consular processing with the DS-260, followed by entry to the United States as a new permanent resident. Applicants must complete an affidavit of support, demonstrate U.S. domicile for the sponsor, and satisfy public charge requirements. Overall, This provides a clearer and more reliable pathway than attempting to revive a lapsed status through SB-1 after a long absence. Next, we will outline the steps to complete an I-130 case. Begin by confirming the qualifying relationship, such as a U.S. citizen spouse or an adult U.S. citizen child. File the I-130 with appropriate relationship evidence, then await USCIS approval and respond to any evidence requests. After approval, the case moves to the National Visa Center, where you will pay fees and submit civil documents, along with the affidavit of support. Complete the DS-260 online and undergo a medical examination with a panel physician. Prepare for the interview by organizing originals, translations, and relationship evidence. Attend the consular interview and address any admissibility concerns. Upon approval, you will receive the immigrant visa and travel to the United States, after which the green card is issued. Finally, maintain residency by filing taxes, preserving ties, and planning for travel appropriately. To help you visualize risk over time, let's look at a timeline. This timeline charts increasing risk as time abroad grows. Under 6 months, most permanent residents can re-enter routinely, though individual circumstances vary. From 6 to 12 months, questioning can increase, especially without strong ties to the United States. Beyond 12 months, the risk of abandonment rises. After 24 months, SB-1 applications face intense scrutiny. Past 4 years, denials are common. At around 10 years, SB-1 approvals are rare. A re-entry permit can help for planned travel but does not cure many years abroad after it expires. Consequently, beyond 2 years, the I-130 path typically becomes the primary strategy. With that context, let's compare the two paths side by side. On the left, SB-1 requires convincing proof of continuous intent and circumstances beyond one's control, which face strict scrutiny. Approval odds diminish markedly after about 2 years and approach zero around a decade. The process can be time-consuming and emotionally taxing and is based on reviving prior permanent residences. On the right, the I-130 route involves a new petition from a U.S. citizen spouse or adult child, offering more predictable steps and immediate relative categories without annual quotas. This approach has a higher likelihood of success in long absence scenarios because it does not hinge on refuting abandonment. Next, let's organize the documents you will likely need. This table organizes typical documents by pathway. For SB-1, proof of continuous ties to the United States and evidence of circumstances beyond your control are critical, along with a detailed absence timeline and any prior documents such as an expired green card. For I-130, relationship evidence, the affidavit of support, civil documents, the DS-260, and the medical exam are standard. Both routes involve consular interviews. A backup plan is advisable in either case. With the paperwork in mind, let's test your understanding with a quick quiz. Question: if a former permanent resident has been abroad for approximately 9 years without a re-entry permit, which pathway is most likely to succeed? Options: A. SB-1 returning resident visa, B. I-130 filed by a U.S. citizen child age 21 or older, C. renew the old green card at the airport, D. apply for asylum instead. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. An I-130 filed by a United States citizen child age 21 or older. After close to 10 years abroad, SB-1 approvals are extremely unlikely. The immediate relative category offers a practical and reliable route back to permanent residence. Next, let's try one more quick question. Question: which evidence is most crucial to strengthen an SB-1 application after a long absence? Options: A. contemporaneous documents proving intent to return plus events beyond your control. B. a personal letter explaining hardship without documents. C. evidence of current United States job search only. D. an old United States bank card with no activity. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is A. SB-1 decisions rest on verifiable, contemporaneous documents that show ongoing intent to return and the specific events that prevented return. Explanations without documentation, minimal or irrelevant evidence, or inactive accounts will not meet the burden. With that clarified, let's consolidate the main takeaways. These are the core points. Long absences drastically reduce the viability of SB-1. especially beyond 4 years, and particularly near a decade. For many, the I-130 through a U.S. citizen spouse or adult child becomes the most reliable approach because it does not hinge on disproving abandonment. Immediate relatives are not subject to annual visa quotas. If SB-1 is attempted, the documentation burden is exceptionally high. Proactive planning and professional guidance are essential. To cement the strategy, let's summarize your next steps. Your action plan is as follows. First, assess your time abroad realistically. If it is 2 years or more, the I-130 is often the stronger route. Second, confirm eligibility through a U.S. citizen spouse or an adult U.S. citizen child. Third, if you still pursue SB-1, assemble rigorous, dated evidence and expect strict scrutiny. Fourth, build a well-organized packet using the steps and checklist we discussed. Finally, consult a licensed immigration attorney to adapt these steps to your specific circumstances. As we wrap up, here is a brief closing message. Thank you for watching. If you found this valuable, please like the video, share it with others who may benefit, and subscribe for more practical immigration guides. Post your questions or experiences in the comments so we can continue the conversation.